Most people who own their home outright believe the hard part is behind them. The mortgage is cleared, the kids are grown, the savings are ticking along. What they don't know, and what nobody in a bank or building society ever had an incentive to explain, is that a paid-off home sitting in your name is not a fortress. It is a target. I worked for over 30 years inside the British legal system, the last decade of that in private conveyancing and estate planning, and I now spend my time at a local law centre helping older homeowners untangle messes that a single afternoon's paperwork would have prevented entirely. I want to walk you through 5 specific legal instruments that most people in their 60s and 70s have never heard of, and I want to explain exactly what each one is protecting you against, because none of these risks announce themselves in advance. The first thing you need to understand is that your property title is not a physical document locked in a drawer somewhere. It is a live digital record held at HM Land Registry, and it can be altered. Not easily, not without effort, but it can be done, and it has been done to people who thought ownership was its own protection. Property fraud in this country does not usually involve someone breaking into your home. It involves someone submitting paperwork to the registry pretending to be you. The people most likely to be targeted are those with no mortgage, because a lender's interest on a title creates friction, and older sole owners living in properties that haven't changed hands in decades, because those tend to be straightforward to research using publicly available records. Land Registry offers a completely free monitoring service called Property Alert. You create an account on their website, enter your address or title number, and from that point forward, you receive an email notification whenever a material application is made against your title. A transfer, a new charge, any significant change. You can register up to 10 properties, and importantly, you do not have to be the owner to add an address to your account, which means your adult children can monitor your home from their own login. What the alert does not do is block anything. Its power is speed. If you receive a notification you did not authorize, you contact Land Registry's specialist fraud line immediately. Use the specific phrase that you have not authorized the application and believe it to be fraudulent, and they can place an immediate hold while an investigation takes place. 10 minutes to set up. Free. That is the first document, or more precisely, the first registration, and it costs you nothing but time. The second layer of protection is more structural. A restriction known as Form LL can be entered on your title, and what it does is require that before any sale, transfer, or new mortgage can complete, a practicing solicitor must certify in writing, in their own name and in person, that the person signing the transaction documents is the genuine registered owner. Not a clerk, not a paralegal, not a digital verification. The solicitor themselves, with their regulatory license on the line. Property fraud almost always depends on impersonation, and Form LL forces any would-be fraudster to deceive a regulated professional face-to-face, rather than forging a signature on a form. For most people living in their own home with no unusual circumstances, the property alert alone may be sufficient. Form LL earns its place particularly for landlords, for homeowners who travel or spend extended periods away, and for older people living alone in a mortgage-free property. You apply using Land Registry's RX1 form, and there is a modest fee. Bear in mind that the same solicitor certification will be required when you eventually sell, so factor that into your planning. If you are in Scotland, the relevant authority is Registers of Scotland, and the process differs, so please take Scottish-specific advice. The third gap has nothing to do with fraud, and everything to do with the completely ordinary and entirely unplanned moment when someone you love is no longer able to make decisions for themselves. Most married couples assume that a spouse automatically inherits the legal authority to manage a home, access accounts, cancel direct debits, speak to insurers, deal with utility companies. They do not. Not without a registered document. Without a lasting power of attorney for property and financial affairs, no one, regardless of how long you have been married or how clearly your wishes are known, has the legal standing to manage your financial life on your behalf. The alternative, if something happens and no LPA exists, is applying to the Court of Protection. The application fee is over £300. It carries ongoing supervision costs, and the process routinely takes 4 to 6 months, during which nothing can legally be done with your assets. A lasting power of attorney lets you appoint a trusted person to act for you, while you still have full capacity to make that choice thoughtfully. Since late last year, the government registration fee has been £92 per document. Most people make two, one for property and finances and one for health and welfare, bringing the total to £184. Reductions and full exemptions exist for those on lower incomes or certain means-tested benefits. I sat with a retired teacher last spring, a man I will call Arthur, whose wife had been admitted to hospital following a sudden cardiac event. She handled their finances. He did not know who their broadband provider was, let alone their pension administrator. He had a copy of their wills, but no LPA. For 11 weeks he was unable to act legally on their joint affairs while she recovered. They had done everything else right. The will had been properly drawn up by a solicitor. Nobody had ever mentioned the LPA. Make one before you need it, because once the question of mental capacity has been formally raised, the window to create one closes. In Scotland, the equivalent is a continuing power of attorney registered with the Office of the Public Guardian Scotland. The fourth document addresses something I genuinely believe is one of the most under-discussed financial risks facing couples who own property together. The vast majority of couples in England and Wales hold their home as joint tenants. The rule of joint tenancy is straightforward. When one of you dies, the other receives the entire property automatically, regardless of what the will says. The will does not get a chance to operate. The property passes by survivorship before probate is even considered. That might sound like simplicity, and in some situations it is. The problem emerges at the second stage. Once the surviving partner owns the whole property in their sole name, if they subsequently need residential care, the local authority performs a financial assessment. The threshold in England sits at just over £23,000. Above that level, you are expected to fund your own care entirely. Average residential care fees in England now exceed £1,400 per week. A home worth £250,000 can be exhausted within 3 or 4 years under that model. 2 documents can meaningfully alter that outcome. The first is a deed of severance, which changes the basis of ownership from joint tenants to tenants in common, meaning each of you holds a defined share rather than an undivided whole. This is a land registry application and is relatively straightforward. The second is updating your wills to include what is called a property protection trust, sometimes referred to as a life interest trust. Under this arrangement, when the first partner dies, their share of the property does not pass outright to the survivor. It passes into a trust. The survivor retains full rights to live in the home, to sell it and move, to treat it in every practical sense as their own. But the trust's share does not sit in their name. It cannot be included in a means-tested care assessment. When the second partner eventually dies, the trust dissolves, and the share passes to whoever was named as the ultimate beneficiaries. I want to be clear about what this does and does not protect. It shields the first person's share after the first death. The surviving partner's own assets and their own share of the property remain fully accessible. This is not a complete barrier. It is a substantial partial protection that is considerably better than the alternative. The trust must be correctly drafted by a solicitor. A deed of severance alone, without the corresponding trust provision in the will, achieves very little. Scotland has its own distinct system of free personal care, and the financial rules around care fees operate differently there. Please take specifically Scottish advice, if that is relevant to your situation. The fifth and final area is really two separate things, one of which takes 5 minutes and saves money immediately, and one of which surprises almost everyone I raise it with. The quick one first. If you are the sole adult living in your home, you are legally entitled to a 25% reduction on your council tax bill. It is not applied automatically when your circumstances change. If a partner has died, moved into care, or an adult child has moved out, your discount may not be reflected in your current bill. Ring your local council and ask them to review your household status. While you have them on the phone, ask about the Council Tax Reduction Scheme. It is means-tested, administered locally, and can reduce a bill to nil for those who qualify. Most eligible people have never claimed it because they have never been told it exists. Now the one that catches people off guard. Owning your home outright does not protect it from civil creditors. If a creditor, a credit card company, a personal loan provider, any party who obtains a county court judgment against you, applies for a charging order, that order is registered against your property at Land Registry. When you sell, the creditor is paid from your equity before you receive the remainder. The home you paid off, the equity you spent decades accumulating. I spoke recently with a retired warehouse manager, a man I will call Graham, 66 years old. He had old credit card debts from a period of difficulty in his late 50s. A county court judgment he had not responded to in time because the letter had been lost in the ordinary chaos of a busy house, and a charging order that had been quietly registered against his property while he continued living in it and paying every other bill on time. He had no idea it was possible. He assumed that because he owned the house outright, it was beyond reach. It was not. If a court claim form arrives at your address, respond to it within the deadline. If a county court judgment has already been issued, contact Citizens Advice or a regulated debt charity within days, not weeks. And if you simply want to know what is currently registered against your title, you can download your official title register from Land Registry's website for a small fee. It is a straightforward document, written in plain English, and any charges or restrictions sitting against your property will be listed there. Look at it this week. 5 separate protections, 5 different categories of risk: fraud, legal incapacity, inheritance erosion, care fee exposure, and civil debt. But each one represents the same fundamental truth. A home you spent your working life paying for can be quietly diminished by something that had a solution available the whole time. And most people are never told what that solution is until they are sitting across a desk from someone like me trying to work backwards from a problem that cannot fully be undone. If none of the rest of this stays with you, let the property alert stay. Free, government-run, 10 minutes on the Land Registry website, and it can be done before you close this page. Everything else can follow at whatever pace suits you. But please let something follow. I am not a regulated solicitor or financial advisor. I am a retired legal professional with a long career and a habit of being honest with people about what I have seen go wrong. Nothing I have described here is speculative. These are real mechanisms, real risks, and real protections. You started watching this as someone whose home is easier to research than you probably knew. You are finishing it with a clear list of what to do about that. Take care of yourself and of the home you worked so hard to own.